this oral preparation audio. Basically, in this audio, shall be taking you through what questions you should expect in a criminal proceedings oral question. So basically, I shall be following this topic out list, so as we can ignite the possible questions and also the possible answers. So, criminal proceedings, the first one, we have contents and perusal of police files. So basically, we were taken through of how do you peruse a police file, whereby we looked at a situation where we are given police files, and then we are required to identify the possible offenses as well as disclosed by the facts. So what's important to understand is in criminal proceeding, once police carries out investigations, they come and get suspects, and then these suspects proceed to do what we call statements. So that's where we had charge and caution statements, where a suspect admits to have committed an offense. So that means you have to do a charge and caution statement. And of course, we saw how do you then admit that charge and caution statement. If they are going to rely on it to convict the accused. But basically, all that one lies into the contents and perusal of police files for the purpose of identifying the possible offenses. So 2, arrest, searches and recovery, preservation and disposal of exhibits. So we looked at the process of arrest, and we can see that the police has a reason to arrest anyone who they believe that has committed an offense. So even a private individual can arrest a person, but then if you have arrested this person, you must continue to hand to keep him or to hand him over to police. So you have to understand other police act that a police officer who has reasonable belief that the person has committed an offense, they can continue at arrest that person. So we can have arrest by warrant and also arrest without warrant. Then we shall also look at searches. How do you conduct a search? So if the police also have reason to believe that a certain place has evidence which is very substantial in a matter, then they can come and also conduct a search in that place for the purpose of recovery of evidence. Then also shall look at preservation and disposal of exhibits, which is governed by the exhibits management rules or guidelines. So basically what you have to understand is that there is a chain of custody of how this exhibits or maybe this evidence is recovered, kept after the time when it's tendered in court. And of course, when you are keeping this evidence or maybe these exhibits, you don't want them to be to tamper with a chain of custody. So basically, when we talk about the chain of custody, we mean this process from how the exhibit has been recovered to the storage and how the exhibit has been tendered in court. You have to understand that any evidence that has been illegally obtained, then it cannot be relied in court. If you obtain an evidence illegally, then that means that evidence cannot be relied on in court. So you have to basically look under the disposal of exhibits, because if now you have like marijuana, how do you then dispose it off? I will see that it can be disposed by burning. If you have like now ivory from the elephants, how do you dispose that? You can, for example, order it be taken to where? The wildlife. So they can ask you, assume that you had an exhibit of money as a magistrate's court, make the orders you would make on the disposal of that exhibit. So you have to see which orders can I make. This is money be returned to what? To the owner. You get the point. So you have to be alive to the fact that how do you dispose of the exhibits. For example, if it's fish, how do you dispose of that? So we shall also look at the rights of the suspect while under police custody. So we also looked at the rights of suspects under police custody, where we looked at the right to apply for police bond, of course, which flows from Article 23, which provides for right to liberty. Then also looked at right to be kept in a lawful custody. So that means it shouldn't be kept in unlawful detention, for example, like safe houses. Then right to inform relatives, right to right to inform the relatives, right to access your lawyer. So basically, those are the rights which are available for the suspect, because they can tell you that assume you have a client who has been a suspect who has been taken to a police veil. Please advise on the rights available. So once a person is on a police custody, that means you can apply for what we call police bond, because police bond, you always apply it when it's at the police. So identification of offenses and ingredients of the same. So we looked at different offenses. We looked at theft. The ingredients of theft include exploitation, participation, and the material being something capable of being stolen. We looked at forgery. Forgery, where you are making a false document, then with the intention to defraud. We looked at authoring a false document, where you present a document which is not true, with the intention to rely on that document. We looked at anti-corruption offenses, corruption, abuse of office, embezzlement, and also we also looked at offenses under the Wildlife Act, to include possession of prohibited species. Also, we looked at possession of unlawful arms. We also looked at attempts to export prohibited species, and also encroaching on gazetted areas. So most of those offenses, once you understand them, you just get the ingredients from those very offenses. But those are some of the offenses we looked at in our workshops. So general principles and practical applications of the law of evidence. Of course, we understand that under Section 101 of the Evidence Act, he who alleges must prove, and the burden of proof in criminal proceedings is always on the prosecution, and they must prove beyond reasonable doubt. And we have the case, of course, of Wellington versus DPP, which basically discussed the standard and burden of proof. You have to understand that in Wellington versus DPP, there was a quarrel between a boyfriend and a girlfriend. So when a girlfriend went back home, and this boy goes back home to convince the girlfriend to return back. So in that kind of scuffle, unfortunately, the boyfriend shot the girl dead, and then when he was prosecuted, he pleaded a defense of insanity. So the prosecution was that he ought to prove that he was insane, but of course the court stated that the burden is always on the prosecution to prove beyond reasonable doubt. But also this burden can shift on some circumstances, and for example, where there is insanity, provocation, also self-defense, diminishing responsibility, then the burden shifts to the accused, but it's always on the balance of probabilities. Because in an oral question, they can ask you, under what circumstances can the burden of proof in criminal offenses shift to the accused. So you have to be very clear and straightforward, and begin from Section 101 of the Evidence Act, which basically states that he who alleges must prove, and the burden of, according to the case of Wellington versus DPP and Procedural versus Uganda, in criminal proceedings, the burden of proof is always on the prosecution, and even if it shifts, it's always on the balance of probabilities to the accused, and can shift in instances of self-defense, provocation, insanity, and also diminishing responsibilities, and also intoxication. So those are some of the grounds under which the burden of proof can shift the accused. So evaluation and sufficient evidence in support of a charge. So we say that when you are evaluating evidence, you begin from Section 101, which basically speaks to the fact that he who alleges must prove. Then you talk about Wellington versus DPP on the burden of proof always on the prosecution. Then the standard of proof, Procedural versus Uganda, that is beyond reasonable doubt. So whenever you are evaluating, or maybe you are asked to do submissions, or maybe to make a judgment, you must first go through those preliminaries. Then interviewing of suspects who are in a police custody, so they can tell you that you have been appointed as counsel on brief. You proceed, and your client is now in custody. Please proceed and carry out. A client interview. So basically, what happens is, if you counsel for the defense, you have to ask him questions about his rights. First and foremost, have you been afforded access to your lawyer? Secondly, have you been informed of the offenses you are charged? Thirdly, have they tortured you? Then secondly, have you applied for police bond? So basically, you ask about the accused person about whether his rights were violated. So basically, when we talk about counsel on brief, this is counsel who, for example, if there is a criminal prosecution and you have been hired by the private lawyers to act as a watch on the prosecution, you are counsel in brief. But counsel for the defendant, you are always counsel for the defense. But you find that in some criminal matters, the person even want to hire their private lawyers to work together with the state. So there you are always counsel in brief. So we have looked at evaluation of sufficient evidence in supporting of a charge, then interviewing all suspects who are in police custody, alignment of the accused persons. So you have to understand that alignment now happens when the person is being produced first in court. So when the person is aligned, that means you have to carry out what we call pre-taking. You have to go through the process of pre-taking, and basically we looked at that in the case of Dan versus R, which basically explained how do you conduct a pre. Then also looked at access to police files and pretrial disclosure in criminal proceedings. So if you want to access the police files and under what we call pretrial disclosure, you just write to the state, and then the state will give you the evidence they are going to do what? To rely on. So that's what we call pretrial disclosures in what? In criminal proceedings, whereby the state is going to show you the statements and also other evidence they intend to rely on. So general defenses to criminal charges, of course, the first one is alibi. Most of the people always bring about alibi, that I was not in that place, which is always a general defense. So alibi has been explained in the case of Uganda versus Godi Akbar, and basically it was a murder charge where the murder had taken place in Masaka, and then God Akbar was an MP by then. I think that was his girlfriend, so he was saying that he was not there. So the court used, of course, the phone prints to connect that he was talking with someone who was in Masaka at that very time. So it basically, if you want to understand alibi, but alibi means I was not in that place. So you can also have self-defense in cases of murder. So self-defense arises where you kill the person and you are defending your relative or your property or maybe yourself. That one is a self-defense. Then the other one is insanity. You know, insanity does not lead to acquittal, but the court can find that you are guilty on basis of insanity. So if you are found guilty on basis of insanity, that means you can be taken to the school, you are not taken to these prisons, but you are taken to the hospital of people who are insane. So basically that's some of the defenses you can look at. If it's theft, you can also bring mistake of fact, that it was something which resembles yours. So this can be some of the defenses in criminal proceedings. Pretrial remedies available to suspects who exceeded 48 hours before production. We looked at the application of police bond. We looked at unconditional release, and we looked at unconditional release, and so also a letter to the DPP. These are some of the pretrial remedies we looked at in our criminal workshops. The role, powers, and duties of the Director of Public Prosecution, and of course, Article 120, the DPP has powers to withdraw and institute criminal proceedings. The DPP has powers to in order for investigation. The DPP has powers to give unconditional release if you have applied to him, so that the DPP can institute, investigate, withdraw, commence, and also order investigations on the police under Article 120 of the Constitution. So you have to, because that one can come at any time in an oral question or in an oral exam. So the role, powers, and duties of the Director of Public Prosecution, have looked at that, the framing of charges, defects, and amendment of charges. So basically, when you're framing a charge sheet, you have to make sure that you meet the principle of legality, which basically says that the charge must be provided for by law, the ingredients as well as the punishment. So basically that's what we call the principle of legality. Then from there we looked at defects and amendment of charges. So the charge sheet can be defective, for example, if it's not properly brought under the right section of the Penal Code Act, or maybe it doesn't establish the particulars of the offense, or maybe it's in the wrong court, or it has a wrong party. So that becomes a defective charge, and then you can go for amendment of the charge sheet. Criminal jurisdictions of magistrates courts, we can see that G1 magistrates can sentence up to 20 years. Then we also have chief magistrate courts which can try any other offense except the one which attracts life imprisonment and also a death sentence. So it basically means that under section 161 of the Magistrates Courts Act, which basically provides for the jurisdiction of the magistrates courts. Then the right to counsel and the duties of advocates at the initial stages of the case. Of course, the right to counsel is provided for in Article 28. First and foremost, a client has a right to choose a lawyer of his own choice. But also in criminal proceedings, if it's a capital offense, the state can give you a free lawyer. You have a right to legal representation if you are dealing with capital offenses. The power, authority, and exercise of the discretion to prosecute. These are always by the DPP, who has the powers and authority to exercise these powers, because he can institute, withdraw, and commence proceedings. Sanctioning and consenting to charges. Still, this is also the power of the DPP, who has powers to sanction and consent to charges. Statutory offenses, their nature and defense thereto. So basically, when we talk about statutory offenses, these are the offenses which do not require a mens rea. For example, possession of a firearm. So you don't have to have a guilty mind. As long as you don't have a license, you are in contravening that offense. We also have offenses like selling harmful food. It's also a statutory offense, because there is no mens rea. Because under criminal proceedings, there must be two things: mens rea, one is which means a guilty mind, and also act reus, which means that you must proceed to do an act. So where you don't have mens rea, those ones are statutory offenses. For example, driving without a permit. Secondly, being in possession of a firearm. Thirdly, selling harmful food or products. And also, so those are some of the statutory offenses we can talk about them. So the right to a fair trial and right to legal representation at a trial, these are provided for under Article 28 of the Constitution, which basically speaks to a right to a fair hearing, which includes access to information, cross-examining witnesses, as well as pre-trial disclosure, summoning, interviewing, and examination of witnesses. So court can issue summons to witnesses to come and attend hearings. And basically, if you have tried to bring a client who's very efficient to your case, you can ask court to summon that client. So basically, what happens is that we have to go through examination in chief, which is done by the state, and cross-examination, which is done by the party who did not bring the client. So you have to understand now, how do you do cross-examination or examination in chief, because at any time they are going to tell you that you are counsel for the state, and here is an accused person being accused of murder. Please proceed and cross-examine the accused. So you have to understand that in examination in chief, you ask open-ended questions. For example, where were you at this date? What happened? What did you do next? What did you find out? Those questions: what, where, when, and why. You understand? Those are the questions you asked in examination in chief. Then in cross-examination, you ask questions that requires the accused person or the witness to give you a yes or no. So you say that on this date you were on the market, and the same date you also say you were attending a party. Is that true? Yes. and you were traveling to the party with your father. Is that true? Yes. So basically, that's how when you're examining, cross-examining, you are giving the answers, and then you want this person to say yes or no. So that's the only technique you have to use, that in cross-examining you are giving this person answers, and you want him to confirm or maybe to deny. So we also looked at adjournment, withdrawal, and dismissal of cases. Of course, at any time, if your counsel can ask for adjournment, and it's also under Article 128 that you have a right to seek for adjournment. Of course, you must have a valid reason, which might include falling sick. For example, they can give you a scenario that counsel has been you are going to court, and they told you that your wife is sick and maybe needs a lot of attention. So what would you do at that very matter? So that means you would seek for adjournment. And we also have here adjournment. We have withdrawal and dismissal of cases. Of course, it's the DPP who has powers to withdraw under Article 120, but also a case can be dismissed when it lacks evidence. Introduction and tendering of exhibits in evidence. So basically, we looked at also the process of tendering in evidence, and how do you tender in evidence. For example, if you're relying on a medical report, and the doctor who authored it is in USA, how do you tender in that medical report? So you have to understand that the best way to tender in a document is by the person who authored it, but where that person is not around, then you can use the evidence of the person who participated in authoring that document. So that means in this case, we would use a person who was working at that hospital who also participated in making that document. Then another thing here we are looking at, of course, is ruling on prima facie case and general contents of the rulings. So what you have to understand is usually the criminal proceedings are like this. Once the person is aligned in court, there is what we call pre-taking. If the plea has been taken for not guilty, the court begins to hear evidence from the prosecution. Then after the evidence from the prosecution, they have led all their witnesses and all the evidence they have, the defense does what we call submissions for no case to answer, or what we call prima facie case, that the prosecution has not established enough evidence to warrant the accuser to be put on his defense. So once the court finds that the prosecution did not produce enough evidence, they can enter into a ruling of not finding a prima facie case, and the accused person the case will be dismissed at that very stage, because according to the evidence, it was either discredited in cross-examination, or maybe there was no enough evidence to prove the case or to put the accused on his defense. So that's what we call prima facie case. So rulings, when we talk about a ruling, we mean a ruling, of course, must have submissions for both the prosecution and the state, and also the evaluation of that evidence, and then the reasons or the orders of court. So basically, when you're giving a ruling, you must consider what the state submitted on each issue, and then what did the defense also submit on that same issue, and then what is the court's finding. Then from there, we looked at options available to an accused on the conduct of the defense. We have you can either choose to give sworn evidence where will be cross-examined, you can choose to remain silent, or you can choose to give unsworn evidence. So those are some of the options available to an accused in the conduct of the defense. So conduct of the defense case, once the accused has been put on his or her defense, then we go into what we call now hearing for the defense case. So now the defense also leads its witnesses and also any other documents they could be having, and then after that we go into what we call submissions, like we used to see in modes. So then start to have final submissions, evaluation of evidence, and the contents of the judgment. So basically, when you're making submissions, it depends on which offenses you are having. But assume it's an offense of theft. Let me use theft as an example. You know, when you're making submissions for the state, first and foremost, you have to begin with my Lord Counsel Peter for the appearing for the state, and my Lord, the matter before us today is for submissions. My Lord, the brief facts of the case are that the accused was charged of theft contrary to this section of the Penal Code Act, and my Lord, the prosecution is ready to submit on the ingredients of the heart of theft. My Lord, the ingredients of theft are the following: one, that the item is capable of being stolen; two, that there was exportation or movement of the product; three, participation of the accused. So then you have to submit on every ingredient. Of course, you first talk about the standard of proof, burden of proof, and then after that you talk about each ingredient. You submit on each ingredient, and therefore after that you pray that you find the court finds that the item was capable of being stolen. You also say that the court find that the accused participated and there was expectation. Therefore, my Lord, I pray that the court finds the accused guilty of theft. So now the defense will also come and trying to say that you didn't prove each ingredient beyond reasonable doubt, and basically showing how you failed to prove each ingredient beyond reasonable doubt. And after that, they pray that they find the accused innocent. So when you're making a ruling, now you are the judge. What you do is that the brief facts of the case, as put out by the prosecution, are the following: the offense of theft has the following ingredients. You talk about standard of proof and burden of proof. Section 1 of the Evidence Act, who alleges must prove. As far as the first ingredient is concerned, the prosecution submitted that the person stole a car on this date, and therefore they proved that ingredient beyond reasonable doubt. Then you go to the second ingredient, you also find that like that. Then after that, basically those reasons, therefore the court finds the accused guilty of theft contrary to this section of the Penal Code Act. So even if you forget a section, because they don't have to force you to remember the sections, because it can be a little bit tricky. Even me myself, I don't have them offhand. But what is important that you understand the procedures and the substance of how you can go about those things. So we looked at the final submission, the evaluation of evidence, and the contents of a judgment. Then testing procedures and options. We have you first have to do an aroctus. So once the court has found the accused guilty, we have mitigating factors and aggravating factors. So aggravating factors are done by the prosecution, whereas mitigating factors are done by the defense. So in aggravating factors, the prosecution is praying for a heavy sentence, or maybe the maximum sentence, because first and foremost, this is a rampant offense. You want to send warning to the public, so you are praying for the maximum sentence. So the defense now comes in with what we call aggravating factors with mitigating factors, and they are arguing that first and foremost, the accused is the first-time offender, is very young, he has a family to look after, and therefore you pray for the minimum sentence. So basically, that's how you go about what we can call loctus, or maybe mitigating and aggravating factors. Then sentencing options. Of course, sentencing is always based on the act, because you cannot pass a sentence beyond what is provided for by law. That one is going to be an illegal sentence. But what you have to understand is you can either order sentence, you can either order a fine, or both. Those are the sentencing options that are provided for by law. Supervisory powers of the Chief Magistrate's Courts. We looked at these ones where a magistrate passes an illegal sentence which is excessive and illegal. The Chief Magistrate's Court can write to the Registrar of the Criminal High Court Division, and that sentence can be reviewed under what we call supervisory powers of the Chief Magistrate Court. Commital proceedings in magistrates' courts. These ones now we deal with them when we go to the High Court. And in all capital offenses, we always have what we call committal proceedings, where the person is taken into the Chief Magistrate's Courts and they read to him or her the charges. So once the person has been taken to the Magistrate's Courts and the charges has been read to him or her, then that means you can proceed to be indicted by the High Court. So you have to understand that in Magistrate's Courts, we proceed by a charge sheet, whereas in the High Court, we have an indictment. Whereas in the High Court, we have an indictment. And in all high court trials, we always have to do what we call committal proceedings. Actually, committal proceedings were challenged, but the court stated that these are only pre-trial mechanisms where the defense has to see which evidence that the state has against them. So bail practice in the high court, you have to be prepared for bail application, because at any one time you're going to be asked to apply for bail. So basically you have to understand that bail has been litigated upon in many cases. For example, in Uganda versus Chiza Besigye, where the court talked about the grounds of application for bail. One, that you have a fixed place of abode, you have substantial sureties, and also you are not going to interfere with the witnesses. So bail flows from, I think, Article 23(6) of the Constitution, which provides for right to liberty, but also you must understand also Article 28(3)(a), which provides for presumption of innocence, also gives you where to start from to apply for bail. So if you are being asked to apply for bail, you have to understand that bail can be applied for orally, or maybe it can be by notice of motion supported by an affidavit. So what always happens, they will tell you that you are in court, the client has come, has taken a plea, and then has been entered a plea of not guilty. Please proceed and make the appropriate applications. So at whatever any point you have been made to make an appropriate application, always think about whether making bail for your client is appropriate. And of course, you proceed to apply for bail based from Article 28(3) of the Constitution, which talks about presumption of innocence, Article 23(6) of the Constitution, which talks about right to liberty. And remember that you have right to apply for bail, but you are not entitled to bail. Then you talk about the case of Uganda versus Chiza Besigye, that rape case where Benjamin Odochi stated that the state hadn't even produced substantial evidence to even convict a chicken thief. So the case is very guiding on as far as grounds for application of bail. And then we have one that must produce substantial securities. Secondly, we talk about presumption of innocence, and then that you will be appearing for answering your charges. So jurisdiction and structure of the High Court, and we see that the High Court, of course, under Article 133(9) has an limited original jurisdiction, but basically High Court can have an apparent jurisdiction from the magistrates courts. It can act as a third appeal or maybe second appeal from the magistrates courts. Then jurisdiction and structure of the High Court, preparation, defects in and amendment of indictments. So where the indictment is defective, maybe you have preferred a charge under a wrong section, or maybe you didn't clearly bring out the particulars. For example, where we're talking about robbery, immediately after, during, and before you haven't properly brought out those ingredients in your particulars of the offense, then that means you can seek to amend the indictment. Then legal representation in the High Court. Of course, in all capital offenses, the state can give you a lawyer under Article 28 of the Constitution, which provides that in all criminal proceedings, an accused is entitled to a lawyer. The power of the Inspector General of Government to investigate and prosecute, basically in corruption offenses, we see the IGG also has powers to investigate and also can commence proceedings as far as corruption cases are concerned. The general powers of the DPP to take over prosecutions and to commit cases to the High Court. We can see that these powers are flowing from Article 120 of the Constitution, but also the Indictment Act, which gives a lot of powers to the DPP to include to withdraw, institute and order for investigation in criminal matters. DPP's licenses to prosecute, we also have to understand that the DPPs are the ones who always prosecute with their offices of state attorneys. Then organizing, preparing for and convening High Court criminal sessions. So you understand that we have to have assessors in the High Court. We must have at least two assessors on each matter, and these assessors also must give opinions which are not binding to the judges. So what are the qualities, or what are the qualifications of an assessor? You must not be an advocate, you must not be a servant of the army You must be of mature age, 18 years and above. You must possess a national identification card. Even you must be from that specific custom. So those are some of the things. How do you prepare and convene a high court criminal session? By inviting assessors. So legal representation of a chosen person in the high court. So that chosen person will have said that is entitled to a state lawyer in capital offenses where he cannot afford one, but of course you have a right to choose the lawyer. You have the right to choose the lawyer whom you want to represent you. Then also we looked at role of defense counsel upon receiving instructions before the trial, during the trial, and after. So first and foremost, you as counsel, once you receive instructions, you have to make sure that first and foremost you ensure that the rights of the accused are not being violated. There you can apply for bail. You can also make sure that your client is given medical attention in case he has some diseases. Also, your client is informed of the offenses he or she is being charged, and given enough time to prepare and also to examine witnesses. Then alignment procedure and change of plea. We also looked at the process of pre-taking. Once the accused is being aligned in court, then basically what happens is you have to take plea, and you always have the plea of guilty, plea of not guilty, plea of previous acquittal, plea of pardon, among others. Those are some of the pleas that the accused can do what can be asked to take. And we have the case of Adan versus Ara, which basically explain the process of pre-taking, to include that you must the court must ask the accused person the language he understands. Secondly, explain to him the charges and ingredients, and also ask to plead on each offense. And then the plea must be entered into unequivocally. Then also have preliminary hearings. These ones arises where we want to admit a document. I think we looked at this where the prosecution, the defense did not want to oppose a document. So you do what we call a preliminary hearing, where the state or maybe the defense does not want to oppose any document. You do a preliminary hearing, and that document is admitted. Then 46, commencement, conduct and closure of the prosecution case. So we see that of course the prosecution case starts by reading all its witnesses. Then after the prosecution reading all its witnesses and any evidence they have, then the defense always comes in with what we call no prima facie case submissions. Then ruling on a case to answer. So basically, after the prosecution case closes its case, the defense does submissions for no case to answer, where even the prosecution can reply, and then after that the court gives a ruling which can either be one to dismiss the matter, or maybe to put the defense on his trial. So basically, you have to understand that there are two scenarios. One where the matter is dismissed before the accused is put on his or her defense. That then if the state gets other evidence, they can reinstate the matter. But if the accused, the case has been acquitted after having put the accused his defense, then you cannot bring the same matter basing on the same facts. You have to understand that difference, because they always ask it in orals. Then we're also looking here at termination of proceedings in the High Court. Of course, this is the power of the DPP, that the DPP has powers to withdraw cases at any one point if it's in the public interest to do so, or maybe if there is no lack of evidence, the DPP can proceed to withdraw the cases. Options for the accused in the conduct of a defense. So we looked at very many options. One, to give sworn evidence, to give unsworn evidence, or to remain silent. All those ones are options available to the accused in the conduct of the defense. Confessions, retractions, repudiation, and a trial within a trial. We looked at confessions and who can make a confession. It's below an assistant inspector of police. any police officer above the rank of assistant inspector of police. I think that's under section 23 and 24 of the Evidence Act. Then retraction is when the person now records his confession. Repudiation is when you also deny that you didn't take any confession. Then trial within a trial. The trial within a trial is basically to test the confession, or when someone objects to have taken a confession, we have a trial within a trial. So basically, the trial within a trial tests the voluntariness of the confession. Remember, the confession must, for the confession to be relied on, or what we call a charge and caution statement. One, it must be taken before a person. It could be a magistrate or maybe an instant inspector of police. Then secondly, if the accused denies to have taken the confession voluntarily, we do what we call a trial within a trial. Trial and sentencing of child offenders. So when we talk about sentencing of child offenders, first and foremost, child offenders cannot be sentenced in prisons where they are adults. They have what we call child remand homes where these people are sent, but also they can be sentenced for community service, caution, counseling, among others. Then also we looked at child witnesses and violdiers. We also looked at the violdier, and the violdier basically arises where you are finding that you want to have a child of witness. So you have to, as a judge, you have to ask this child questions and find out whether this child understands the nature of the offense, and also it has sufficient evidence to tell his or her surroundings. So you have to ask questions in that line. What's your school? Where do you go to church? What happens when you lie? That's how you conduct a violdier. The evasion of children-related cases, these ones are provided for by the Children's Act, the evasion, which include counseling, community service, also caution, among others. Then we also looked at opening, conduct, and closure of defense case. So once the defense always begins with making submissions for no case to answer, that the state has not established enough evidence to warranty the defendant to be put on his defense. So once they make those submissions for no case to answer, and the court finds that the prosecution established enough evidence to put the accused on his defense, now the defense begins to read its evidence and all the evidence, and also cross-examination in chief of their witnesses. And then after that, we go into submissions. Then also here we have the order and content of final submissions. Of course, the order and content, the prosecution first makes submissions that the accused will be found guilty. But of course, you begin with the section 101 of the burden of proof, the standard of proof, and then after that, you evaluate the ingredients of the cases you have and the evidence you have on record, and then you pray that the court finds the accused guilty. Then after that, the defense also comes in by also following the same process and basically saying that you did not prove the ingredients beyond reasonable doubt, and then they pray that the court finds the accused innocent and they acquit him. Basically, that's how you go into submissions. Then after that, you look at opening, conduct, and closure of the defense case. The order and content of the final submissions, we have looked at those ones, summing up the assessors and assessors' opinions. So after that, the judge has to guide assessors on one, circumstantial evidence and how circumstantial evidence is treated. Secondly, we also have to guide on if there was a hostile witnesses, how do you treat evidence of the hostile witness, and then you have to guide on the burden of proof and standard of proof to the assessors. Then after that, you invite them to make their opinion, but also the opinion of assessors. If you are going to depart from it as a judge, you must give reasons why you departed from it, but it's not binding to court. But that's basically how you sum up to the assessors. Judgments, contents, and mode of delivery of a judgment. So a judgment is always given on a specified date, and the contents of the judgment, one is of course has the brief facts, the issues, the submissions of both parties, and the reasons for the judgment, the sentence, and also the right to appeal. You have to inform the accused his or her right of appeal, and of course if you're sentencing the accused to 10 years, you must also deduct the years the accused spent in remand. So basically that's how we also go about that. And then after that, we have mitigating factors, aggravation, and remission of a sentence. So mitigation basically means that the defense comes in to ask for a lenient sentence. Aggravation basically means that the accused or the prosecution comes in to ask for a maximum sentence. So then we also have sentencing options, powers, and procedures. You can sentence for, we can have what we call a sentence of fine, we can have a sentence of imprisonment, or both. Basically, that's how you can sentence. Of course, you have the case of Simon Chamanywa, where they removed inhuman sentences like maybe the stroke of canes. That one has been since being removed. Powers and procedures, you must make sure you also inform the accused the right of appeal. Then 60 role of prosecution and defense counsel at sentencing and Rockstars mitigation. So basically here we are looking at how do you do aggravating and mitigating factors by both the prosecution and the defense. And the prosecution is basically asking for a lighter sentence. Prosecution is asking for a maximum sentence, whereas the defense is asking for a lighter sentence. So you can ask for a heavy sentence first and foremost if the offense is rampant. You want to send a warning to other offenders, and also the state wants to reduce these crimes. So those are the reasons you can rely on, whereas the defense can use one being young and through was very remorseful. He has a family to look after and is the first time offender. So basically that's what we can look at as far as criminal oral exams are concerned. So what you have to understand is you have to understand these things like the way they are given, just to read and understand the whole syllabus as a whole, because any question can come from anywhere. So you have to only be understanding, and you realize that in an oral exam, you are most especially relying on your understanding more than you are using the cram work. So please don't try to cram, just read to understand. Otherwise, we remain the Pass Bar team. We wish you success in your criminal orals exams. We were also scared like the way you are, but then we did it. But in case you want to be to join our mentorship program, you can reach me out in the number in our bio. We are preparing for oral exams, then you can be part of us, but also we shall be answering questions and answers for the final exams, and also for term 3, and also shall be in the middle of the holiday. We shall begin our mentorship program, because you don't have to go into the holiday and just forget about the bar course, because when you come back you will be beginning from scratch. So criminal proceedings is doable. Don't fear it. Please subscribe, share, like, and comment, and also wait for other analysis that will come for other category A subjects, because we want to cover all of them. So we remain past the bar. Please have a blessed oral week.